What would you do if two ATF agents showed up on your doorstep, asking about the guns you own? Most people make a mistake in the first 30 seconds. A mistake that can cost them their freedom. I know because I've sat across the table from people who made that mistake, and I've spent over 20 years as a criminal defense attorney trying to undo what could have been avoided with 3 simple words. Today you're watching body cam footage from one of those encounters, a man we'll call Mike. He's a free man right now because of what he said when the federal government came knocking. And by the time we're done, you'll have the exact words he used, and you'll understand the constitutional tripwire they set off the moment they left his mouth. The body cam timestamp reads 10:47 km. The lens is fisheye, slightly distorted at the edges, and you can hear footsteps crunching up a gravel driveway. 2 ATF agents, plain clothes, but with badges visible on their belts, and walk up to a modest single-story home in a quiet suburban neighborhood. The lead agent knocks 3 firm, authoritative raps, and you hear a dog bark inside. The door opens. Darren, a man in his late 40s, looks out, clearly surprised. The agent's voice is calm, almost friendly. "Morning, sir. We're with ATF? We'd like to ask you a few questions about your firearms purchases. Do you have a minute?" Now pause right there. Most people would do exactly what Mike almost did. They'd feel the pressure of a badge, think being polite means answering questions, and they'd start talking, but here's what you need to understand. The moment those words left the agent's mouth, Mike was standing inside the most powerful legal fortress in the modern world, the threshold of his own home. And federal agents cannot cross that threshold without a warrant or your voluntary consent. The Supreme Court has been crystal clear on this for decades. In Payton v. New York, the court held that warrantless entry into a home to make a routine felony arrest is presumptively unreasonable under the Fourth Amendment time. The home is different. The curtilage, the area immediately surrounding the home, like the porch and front door, enjoys the same protection. In Florida v. Jardines, the justices ruled that bringing a drug-sniffing dog onto someone's front porch without a warrant was a search because that area is part of the home's protected zone. So the moment Mike opened his door, those agents were standing on constitutionally sacred ground. They knew it, and they were trained to turn that encounter into a consensual chat. Because once you consent to talk, once you voluntarily step outside or invite them in, you start dismantling that fortress brick by brick. Let's rewind the body cam. The agent's question hangs in the air, and Dave, to his credit, doesn't immediately start spilling information. He does something subtle but smart. He doesn't step out onto the porch, and he doesn't open the door wider. Instead, he stays right in the doorway, blocking the entrance with his body. He asks, "What's this about there?" The agent answers vaguely, "We've received some information about purchases you've made. Just want to clear a few things up. Can we come in?" The agent gestures toward the living room hem. Now, this is the first major pivot point. If Mike says, Sure, come on in," he has just given consent to enter. And anything they see in plain view from inside the home, "If you change your mind, give us a call." And they left. The body cam footage cuts off 30 seconds later as they walk back to their vehicle. Mike never answered a single question as they walk back to their vehicle. Rice never answered a single question about his guns that day, and he never got charged. I later reviewed the file. There was a sealed informant tip that had no corroboration, but they were fishing for a confession. They had no warrant, no exigent circumstances, and after the invocation, they had no interrogation path. Mike's 3 words closed every door they were trying to open. Now let's break down the legal machinery that protected him. Because this isn't just one, right? It's a layered defense. The first layer is the physical space and the threshold. The Fourth Amendment protects you from unreasonable searches and seizures, and the home gets the highest protection. The ATF can't just walk in. They can even peek inside without a warrant or consent. If they had a warrant, Mike would have the right to see it. You can ask them to slip it under the door, and you can read it before you open up. But they didn't have one, and they didn't claim to. So the physical fortress held. The second layer is the right to remain silent, anchored in the Fifth Amendment. You are never required to answer law enforcement questions, especially not about your constitutionally protected activity. Owning a firearm is a right under the Second Amendment, and while the government can investigate illegal possessions, you are under no obligation to help them build a case against you. The ATF's question about his guns wasn't innocuous. It was a direct inquiry into the very items that could have landed him in prison if a prosecutor could twist his words. So his silence wasn't rudeness. It was the exercise of a fundamental right. The third and most powerful layer was his invocation of counsel. By saying, "I want a lawyer," he didn't just stop questioning. He legally required the agents to cease all interrogation. And here's a nuance most people miss if you only say, "I don't want to talk," that can be ambiguous. And officers can later claim you didn't clearly invoke your right to remain silent. That's what Berghuis v. Tompkins taught us. Silence alone isn't enough. You have to speak up to shut it down. But saying you want a lawyer is the strongest form of invocation. It immediately places you in a protected category where any further questioning is presumptively coercive. If the agents had pushed, after that, any statement Mike made would have been inadmissible under Edwards and likely would have opened the agents and their agency to civil liability. That's why they backed off. You might be wondering, what if the ATF had a warrant? That changes the dynamic, but it doesn't erase your rights. If they present a warrant, you can and should examine it. Look for the correct address. Correct address, the signature of a judge, and the specific items to be seized. You still do not have to answer questions. You can step aside and let them execute the warrant, but you should clearly state, "I do not consent to this search. I want my lawyer present." That statement may matter later, if the warrant is flawed or the search exceeds its scope. But in Mike's case, no warrant existed, and he never had to make that choice. I want to circle back to the exact words, because the phrase, "I want a lawyer before I say anything else," is a legal scalpel. It's not just, "I want a lawyer." Adding, "before I say anything else," closes a loophole. Some courts have found that saying, "I think I might need a lawyer," is too ambiguous. Davis v. United States held that the request for counsel must be clear and unequivocal. Mike's sentence left zero room for interpretation. He didn't want to talk until he had a lawyer. Even if the agents had tried to reinitiate conversation later, would have been scrutinized heavily under the Edwards rule, which presumes that a subsequent waiver is involuntary if police initiated the contact after a clear invocation. It's a one-way door for law enforcement. Once you push that button, they have to stop. Now, I've been in this game for 2 decades, and I can tell you that the biggest mistake I see isn't ignorance of the law, it's the social instinct to cooperate. The agents knock. And you feel like you have to explain yourself. That urge is what they bank on. The ATF, like any investigative agency, trains its agents in elicitation techniques. They build rapport. They make it seem like just a friendly chat. We just want to get your side of the story. But in the federal system, there are no friendly chats. Every word is recorded, often on body cam, And every inconsistency becomes a potential false statement charge, so your script has to overwrite that instinct. And the script is simple. Recognize the encounter for what it is, a legal boundary test, and respond with a phrase that invokes the highest constitutional protection you have. Let's walk through a slightly different version of this scenario. So you see how the same phrase applies. Suppose you're not at home. You're at a gun show, and ATF agents approach you in the parking lot. You're not inside your home, so the threshold protection is gone. But you still have the Fifth and Sixth Amendment tools. You can ask, am I being detained, or am I free to go? If they say you're free to go, you can walk away, no need to speak. If they say you're being detained, you're now in a custodial situation, and you immediately say, I want a lawyer, before I say anything else. That phrase still acts as the tripwire. It protects you regardless of location. The only difference is that at home, you also have the fortress of the threshold. Use every layer you have. I want to leave you with something concrete. The next time you see a video of federal agents at someone's door, watch what happens in those first few seconds. The person either steps aside, starts talking, and slowly surrenders their rights, or they hold the line, physically and verbally. Mike held the line, and you can hear it in his voice on that body cam recording. He wasn't aggressive. He wasn't scared. He was just certain. He knew his line, and he delivered it. But what happens when those agents don't have body cams, and it's your word against theirs? What happens when they claim you gave consent and there's no recording to prove otherwise? That's a whole different chess game, and we'll get into that next time.